Good day and welcome at the KVV Training Center. Today we're going to discuss our standard offer to purchase. The idea is that you download it from our website and make use of it when you sell your property privately. I'm going to guide you through all the clauses and hopefully assist you to understand the clauses so that it can be completed in a manner that reflects a true reflection of the intention of the parties. Let's start at the preamble of the agreement. Just one or two things to take note of. There's a few requirements for an agreement to be valid, minimum requirements. It's the consensus between the parties. It's the legal capacity between the parties, the legality of the contract, and then obviously the enforceability of the contract. It needs to be a valid reason why you're entering into that agreement. For example, you can't enter into agreement to act in an illegal manner. The formalities in terms of the sale of land, of immovable property, that makes an agreement a valid agreement is the following. There needs to be the description of the parties, description of the property, the purchase price, and it needs to be in writing and signed by both parties or all the parties involved. You are therefore not entitled or not allowed to have a contract for the sale of immovable property verbally. Alright, let's have a look at the preamble of our agreement. Firstly, you'll see there's the description of the parties, description of the seller. Make sure that the registered owner of the property is the person you're negotiating with if you're the buyer, and obviously if you're the seller, make sure that the property is registered in your name. Should you act on behalf of a company, a trust, or any other legal entity, you need to make sure that you have the power of attorney to act on behalf of that entity. Also, what's important while looking at the description of the property of the parties involved, the buyers and the sellers, is marital status. For example, if somebody is married in community of property, both spouses need to sign. Alright, and then still in the preamble of our agreement, the description of the property. I think what's important here, we make use of deed searches, which gives us the earth number as well as the street number, so we can make sure that we're transferring the correct property. What's also important, for example, with sectional titles, to make sure that there can be a difference between the unit number and the door number. So it's important that when you complete the offer to purchase, you make sure about those facts so that the correct property can be transferred. I know most estate agents make use of the Lightstone report, which we can also assist you with obtaining that information if you're not sure about it. Alright, then at the start of the agreement, Consumer Protection Act, the clause regarding the Consumer Protection Act. Basically that is only relevant if the seller is a developer or somebody speculating with property, and selling the function of selling property is their normal course of business. Then that clause is applicable. The clause in respect of the condition of the property and warranties, I just want to highlight one or two words there or phrases. It's important that you make sure when you purchase a property on the conditions, and there might be servitudes, for example, in the title deed. We can also assist you with obtaining the title deed so that we can make sure about the restrictive conditions, like for example a servitude. When you as a buyer purchase a property, you purchase the property with the conditions as per the title deed. And then also in clause 2.2, we refer to foot stewards. I think that's a term very well known. And basically, if I can explain it to you in simple terms, is that yes, when you purchase a property, people like to make use of the phrase, you buy it as is, which is true. But there's also a test to say that a reasonable person would, as a seller, what would a reasonable seller do? A reasonable seller would identify and show you any defects that the property might have, so that you're aware of it. And on the other side, a reasonable purchaser will also act in a certain way to at least make sure he he does his homework, he walks through the property, he just doesn't buy the property off the internet or photos, and he acts in a way that a reasonable person acts. You therefore, as a seller, to come back to Footswitz, are not allowed not to disclose any defects that you are aware of. If you do not disclose it, and the purchase at the later stage can prove that you were aware of these defects, you could be held liable. Alright, then also under that clause there can be certain warranties given by the seller. For example, the pool pump's working or not working, swimming pool pump leaks, roof leaks, damp. That's normally the issues we encourage the parties to discuss and have building plans, and those are the type of things that normally cause problems at the later stage. So rather discuss that and get the warranties in place if you're the purchaser, and if you're the seller and you're aware of defects in terms of maybe a gate motor not working or the swimming pool pump not working or the swimming pool leaking, for example, rather disclose it here so that the purchaser can't come at a later stage and take you on or sue you in respect of those defects. Okay, and then the clause regarding purchase price. It's important that you, especially if the seller is VAT registered in terms of this matter and it's a VATable transaction, should you not clearly agree on a purchase price whether it's inclusive or excluding VAT, then by law it will be inclusive of VAT. So make sure if it's a VATable transaction, whether your purchase price that you're offering or accepting as a seller includes or does not include VAT. Just communicate that. Although most property transfers does not include or exclude VAT, and then you would be, as a purchaser, pay transfer cost and transfer duty on the price that's been agreed. So that's basically in terms of the purchase price. The clause regarding payment of the purchase price, there's normally a few ways that you can secure the purchase price. Number one is a cash offer. You then complete in this clause to say, listen, I'm purchasing your property, for example, for R1 million, and I would secure the purchase price within 30 days or whatever you feel comfortable with. That purchase price will then normally be paid into the transferring attorney, and he will issue guarantees for the cancellation of the seller's bond and whatever other expenses there might be, and the balance, the proceeds will then be paid to the seller on date of registration. We, however, mostly see in the market these days that people finance their properties. You will also complete it here. For example, if the purchase price is R1 million, there will be a deposit payable for 100,000, for example. You complete it there, and then the balance of the purchase price, if there's a purchase price R1 million, deposit 100,000, and 900,000 will then be financed through a financial institution. Please, just as a guidance here, make sure that when you break it up between deposit and the amounts that needs to be financed, that it adds up to the full purchase price. All right. Then the clause regarding suspensive conditions. Now, what is a suspensive condition? A suspensive condition is a condition that, should this condition not be met on the agreed date, then the contract will be null and void. For example, if somebody had to sell their property and for example in 60 days and they do not sell that subject to property, this contract would lapse. Or if somebody said this offer is conditional, that they need to secure finance from a financial institution, should they not secure that finance at the amount that was agreed upon, they can walk away and this contract will be null and void. Alright, that's a suspensive condition clause. Just please make sure you complete the details of, for example, the purchase, the bond amount and the subject to properties if it needs to be sold. Alright, now the clause regarding occupation or occupational rent. This is a very interesting clause, and we often find that this is one of the clauses that causes the most arguments or problems in a matter, it's important that you complete this contract and make sure you negotiate up front in terms of the occupational rent amount as well as date of occupation. Most transactions or matters this being completed is on that occupation will happen on date of transfer. But in the alternative, if the purchaser takes occupation before date of registration, he would pay occupational rent to the registered owner, which is the seller. But it might also happen that registration takes place and the seller only vacate the property at a later stage. Then the seller would pay occupational rent to the purchaser, who then obviously after registration is the new owner. Okay, regarding the clause on the transfer, it's the seller's decision to appoint a transferring attorney. There can be 1 or 3 attorneys. Just quickly, a transferring attorney, which transfers the property from the seller to the purchaser name. A bond attorney, which registers the bond on behalf of the purchaser. And then a bond cancellation attorney, which cancel the existing bond, the seller's bond over the property. It can be 1 or 3 attorneys that's involved, and it's normally the right of the seller to appoint the transferring attorney. All right, possession and risk. Possession risk on the property normally transfer on date of transfer from the seller to the purchaser on date of transfer. Just a heads up, it's important that you keep all your insurances in place if you're the seller, because something might happen just before transfer to the property, and then if you've cancelled your insurance before transfer, you might find yourself in troubled waters. On the other hand, especially if it's a cash deal, make sure if you're the purchaser that you get the right insurance in place from date of registration. If the purchaser obtains a bond, the bank will advise you and would force you to take insurance, because the bond obviously the house is their security for the finance that they're providing you. All right, then the costs. The clause regarding the costs. There's 3 sets of costs. Transferring cost, which would be paid to by the seller. Bond registration, transferring cost, which would be paid by the purchaser. Bond cancellation cost, which would be paid by the seller to cancel an existing bond. And then if the purchaser makes use of finance and we need to register a bond, he would be liable for paying bond cost. All right, so that's the cost. In terms of the cost, our website also have our brochures, or you can contact us to provide you with quotations so that you know exactly what the cost would be and the implications of that. All right, the clause regarding fixtures and fittings. The fixture and fittings is also an interesting one, and if I may explain it in a simple matter, I always tell the clients that if you take a property and you turn it upside down, whatever does not fall out, you should leave as the seller of the property. So it's any fixture or fittings. I know, say for example, things that normally causes issues is a koi pond or bar, chairs, the bar chairs, little things like that. Make sure you discuss that when you negotiate, and what items will be left as fixtures and what would the seller remove. All right. Then the clause regarding the compliance certificates. There's a few certificates that, and depending on transfer, that need to be obtained. Normally it's for the cost of the seller, and those certificates are in certain areas the Beetle certificate, which most areas in England we don't need to obtain those. But the most common one what the seller needs to provide us with is electrical compliance certificate. That's normally valid for 2 years, and it needs to be issued by qualified electrician, and each transfer of property need to have such a certificate. Then there's also the gas, if there's any gas at the property, a gas certificate that needs to be issued. And the last one that I referred to, or that's in our offer to purchase, is the electrical fence certificate that we will also have to obtain should there be an electric fence at the property. Okay, then other certificates that or clearance certificates that I just want to refer to, the clause in terms of the homeowners and body corporate. What's important here is that should there be a homeowners or a body corporate involved, we will make sure that we get a levy clearance certificate, and to make sure that all the arrears of levies is up to date, and that the purchaser does not get a property with any arrears. We also, just as a side note here, obtain rates clearance certificates from the municipality to make sure that there's no arrears on any figures when we transfer the property. What's also important, if you buy into a estate or a property where there's a homeowner's or body corporate, it's advisable that you obtain the conduct rules of that homeowners or body corporate to familiarize yourself with that and make sure that you know what you're buying into. Especially the most common problem we get is, for example, if there's a restriction on the amount of dogs you may have at the property, or any buildings or alterations that you're allowed to. Make sure that you familiarize yourself with it. Right, then the breach clause, this can get quite complicated. And basically what our standard offer to purchase refer to, should any party be in breach, whether you're the buyer or the seller, the non-defaulting party would normally advise the transferring attorney about it. The transferring attorney then write a letter to the defaulting party, place them in breach, and then according to our agreement, you give that defaulting party 7 days to remedify that breach. Should he not remedify the breach, he's in mura, which then means the non-defaulting party has got certain remedies that he can enforce. For example, specific performance, cancellation of the agreement, and or claiming for damages. Alright, then the clause regarding acceptance of the offer. How it works is the purchaser, once you've negotiated the terms and the conditions in the agreement, the purchaser normally makes an offer to the seller and say, this is my offer and this is my conditions, and you need to accept it before a certain day. Normally, let's say 48 hours or 72 hours. What's important here for the sellers is that you do accept or decline that offer within that said amount. Should you only accept it after that date, then it becomes a counter offer, which you would then have to notify the purchaser of it, and he will then have to co-accept it again, or if you, for example, change any conditions that's different from the original offer. All right, so that's important. All right, then there's also a clause for any special conditions, whatever you might have. For example, building plans needs to be first put in place, or the Wendy houses needs to be left, or certain maybe koi fish pond, or whatever the case might be, or any other conditions that you want to agree upon, you can make use of that clause. I just want to quickly run to the clause regarding estate agents commission. Should there be commission, the seller is normally liable of paying it, and that's something that it would be recommended that you negotiate that commission with the introducing party or the agent before you sign this agreement, so that there's no conflict of the amount or percentage that will be paid on transfer. Should there be no agents involved, you can delete that clause, and it will not form part of your private transaction. Right, and then the last closing few conditions, I just want to bring it under your attention that after there was agreement that was accepted by the seller and all the parties is happy with it, should there be any amendments after that date of acceptance, it needs to be in writing and signed by both parties. For example, if the parties agreed that occupation would be on date of registration, and at a later stage the purchaser, for example, wants to move in earlier, you need to notify the transferring attorney about the amendment. An addendum will be drafted to reflect the true new intentions of the party, or where it's been amended, and needs to be signed by both parties to be of any force and effect. All right. Then in closing, make sure that all the parties involved sign it. It's advisable that you also sign the offer to purchase. It's advisable that you get witnesses to co-sign. It also helps us to, when you complete the information sheet, and also provide us with your FICA documents as well as your existing bond for the seller. And it also is, we would recommend that you send your current levy statements and rates and taxes account so that we can start applying for those figures. That will help us to speed up the process and assist us with your journey of transferring this property, either whether you're selling or buying. Should you require any further information or assistance in terms of our offer to purchase, we will gladly assist. You can contact our offices or just visit our website for more information. Thank you for your time.